by way of background and introduction on me, I work for a big law firm called DAC Beachcroft. I'm a board director there and a partner. It employs 2,500 staff, and it's big and all over the place. Geographically speaking, obviously, not literally. I also work for a health education business called Clarity Informatics Group Limited, and I am the CEO of that business. So I like to think I can at least empathize with you guys when you are interacting with my wonderful fellow colleagues and profession lawyers. So I've got a couple of different perspectives. What we're going to try and address now in the next few minutes is what the legal essentials are for startup businesses. I think to begin with, I would say that you need to prioritize. So when you're a small business, you don't have infinite resources, so you're not going to be able to address all legal and commercial risks. You have to decide how you're going to allocate a very limited amount of money that you may have and time to addressing things that are perceived as legal risks. I think the best way of dealing with it, in my experience, is looking at the reasons for complete disaster and working backwards from there. And I've got quite a bit of experience of seeing businesses that have encountered disasters. And so if I can give you some of their experiences, and hopefully we can ensure that in respect of your businesses, you don't encounter something similar. To start with, when you're setting up a business, I think it's always useful to think about ensuring that you don't lose your house. And there's a couple of good ways of not losing your house. It's to ensure that you set up a corporate structure of some description that limits your liability. So if you want to just set up tomorrow as a sole trader, you could do so. But in the event that you were sued because you provided poor services, or any other liabilities arose of your business, then potentially you would expose all of your personal assets. So one obvious thing that you can do is incorporate as a limited company. By doing so, you protect your house. Another thing to do is not give a personal guarantee in respect of any liabilities that you enter into on behalf of your business. So if you're looking to get some premises, your landlord will likely say to you, oh, we'll need to get a personal guarantee from you, and you should resist that. I mean, it's not always possible to do so, but in terms of some absolute essentials, putting yourself in a position where you're not exposing yourself to very high levels of personal liability is clearly a pretty good idea. Another thing that people or businesses seem to get wrong is when you set up a business, you need a name. And you need to think a bit about legal issues when you're naming your business and your products. Your name may be used by somebody else, and you may have ideas about how you're going to expand and grow your business or particular product ideas in other jurisdictions. And again, they may be used in other jurisdictions. So I would encourage you to get yourself vaguely familiar with trademark law, and you can do so by going to the Intellectual Property Office website, and it will give you an overview of what you need to think about. But broadly speaking, you can't, if you call yourself something descriptive, then you won't get a trademark for it. So, and everyone wants to call their business something descriptive. It's just a natural thing to do. It's like, how do I somehow create a composite word that describes what I'm doing? But actually, when you think of some of the strongest brands they're not in any way descriptive of the services that are provided, you know, Google and Apple and so on. It doesn't need to be descriptive. And as I say, the problem that you have if you call your business or your product something descriptive is that you can't get the trademark. And if you can't get the trademark, other people can trade using the same name, and in the long term, you may have a bit of a problem. There's a bit more to it than that. Obviously, armies of intellectual property lawyers make a living on the back of these sorts of issues. But in a nutshell, think about the name. Another thing I would suggest you address is personnel. So in my experience, the SMEs that fail, or if you like, have major legal problems, fail because of personnel issues. And these issues arise because the founder of the business hasn't thought about who the essential people are within that business that are going to help grow that business, and hasn't aligned their incentives to the long-term growth of the business. So this is connected to corporate matters, shareholdings, share options, those sorts of things. I think it's often the case that a founder sets the business up and they get a bit greedy, they keep everything for themselves, and then they have a bunch of people who initially are engaged and think it's really exciting and they're really liking what's going on. But then after a while they think to themselves, hold on, this man or lady, they're taking out all of the profits of the business and I'm not getting anything in return. And at some stage further down the line, there's a danger that these individuals think, I can do this myself. This isn't rocket science. I could just go up and set my own thing up. And the amount of occasions that I hear where you have individuals who've been involved in the formative stages of a business who have basically set up shop next door in competition is considerable. You can address this in a couple of ways. You can lock them down. So there's the carrot and the stick. So you can put lots of nasty employment contracts in place that prevent them from doing things like competing with you and so on. So you can do all of those things. But the more effective way of ensuring that they continue to help your business grow is the carrot. And as I say, I would encourage small businesses to think about how to incentivize through things like share option schemes or shareholdings their key employees. You should also bear in mind that when you're setting up the business from the outset, you're setting it up with a view to doing something in the future. You're not going to run the business in perpetuity. It's pretty unlikely. It's highly likely that you have a view that you want to sell the business in, say, 5 to 10 years. And if you're going to exit the business, you need to think about how you're going to exit. So creating a corporate structure that will give you the most, if you like, tax-efficient exit is probably a good idea. So depending on the nature of your business, you can, if you speak to accountants or lawyers, they may be able to advise you as to some of the tax qualifications that you can apply for, qualify for by structuring your business in a particular way, which might actually mean that when you sell your shares, you pay a much lower rate of tax than otherwise. So always think about exit. And in putting together, if you like, if it is a company that you set up and a shareholders agreement, you need to think, how am I going to make this an attractive proposition to any potential investor? So, it may be the case that if you have, 5 shareholders in your business, you don't want to be in a position where you can't take investment unless you have the consent of all of those shareholders. You actually might want to ensure that if a majority of the company want to take it in a particular direction, they can force the minority to do so. That makes it a more valuable proposition, because it means that if you are in control of the majority, you can run the business in the way you want to run it. So when creating, if you like, that constitution of the company, when incentivizing your key staff and giving them shares and involving them in the business, you need to be really smart about how you structure the business itself, because if actually you create a position where you've inadvertently caused some form of deadlock, where decisions can't be made, where people can hold you to ransom, and where you can't take the business in the direction you want to, it could cause some very, very significant adverse commercial implications. One thing you will obviously want to do at some stage is sell your services. And I wouldn't suggest that you need complex, expensive commercial contracts. If you've limited your liability by setting up as a company, initially, you could arguably provide your services on anyone's contracts. You could sign up to anything, any horrible indemnity, any awful 200-page long contract given to you by the customer. You could theoretically sign up to anything, because your maximum exposure is the share capital of the business, so it might only be £100. So if everything goes wrong and they claim on their £10 million indemnity in your contract, you'll give them whatever cash you have in the business plus £100. So early on, you don't need to burden yourselves with too many complex commercial contracts. However, there are some things that you will want to do. You want to protect your intellectual property and confidential information. So when contracting with partners and customers and so on, you always need to make sure that you're not inadvertently leaking or giving away all of your trade secrets. And many kind of like customer-friendly contracts will say, if you're providing services to them, oh yeah, we'll own everything that you are providing to us. And you need to be very, very careful that you don't inadvertently contract to give away all of these assets within your business. I know a software development business I encountered, and there was nothing wrong with these guys. They were working really hard, they weren't paying any attention to legals, and they thought that each time that they developed some software for a client that they could do that piece of work, get paid, and then go on to another client and do another piece of work using the same sort of software again. But actually the first client that engaged them got an assignment of all of the intellectual property in a little clause in the contract which they didn't read. And so the second client then bought the services and was about to go live with the software, and then the first client, who was a direct competitor of the second client, rang them up. Second client was actually my client. Unfortunately, I was on a very difficult side here. Rang them up and said, "Oh, do you know that you're about to launch a software application that infringes our intellectual property rights?" And the second client said, "Well, no, not at all. No, we took a license from these developers, but actually the developers had given away all of the IP as part of the previous engagement." And this happens quite a lot, so be really careful. As you're trying to build your business up, something you should need to address early on in the contracts is that you don't inadvertently give away the intellectual property. As it was, we then got all our money back from the developers, but it virtually put them out of business. So they had this, they were so close to having this really profitable business where they were licensing the same thing over and over and over again to lots of competitors in the same space. But it turned out the thing that they built actually was then assigned to their first customer, and that was it, they were finished. So something to look out for. Confidentiality as well is kind of useful, I think, from the point of view of bluff. So no one ever sues anyone for breach of confidence, really. I mean, it occasionally happens in law textbooks, but not in the real world. It's very, very difficult to show that there's A, been a breach of confidence, and B, that the information was confidential in the first place, and C, that there was any loss. However, you do look more credible if you're going to see a prospective customer or working with a partner if you have an NDA. So having some form of standard non-disclosure agreement presents you very well to your counterparties, and you know, as a matter of good practice, I think you ought to put those things in place. As I say, they're very difficult to enforce, but conventionally most businesses use them, and if you are conducting negotiations with a potential partner and you don't have an NDA, you look a bit naive, and if I was on the other side, I would be thinking, okay, it's a bit odd that these guys haven't presented an NDA, so we can probably get away with all sorts with them. So do bear that in mind. And finally, lawyers. You don't have to accept that you have to engage a law firm on an hourly basis. If you're doing a corporate transaction, as was referred to earlier, why would you agree with the law firm that they can receive £100,000 in the event that the transaction aborts? You should say to them, in the event that the transaction aborts, we're not going to pay you anything. Okay, maybe we'll accept in exchange for that the fees that would otherwise be £100,000 if actually the transaction goes through should be £130,000. So you could, all of that anxiety that was referred to previously could have been de-risked if actually you'd struck a better deal with a law firm. Law firms do these deals all the time, particularly on corporate transactions, because many corporate transactions, it's the case that the people buying the thing need finance for it. And if the transaction falls over, it sometimes falls over because they don't have finance. And if they don't have finance, they can't pay your fees. So conventionally in the corporate legal world, abort fees are very, very common. So if you're going to sell your business, negotiate yourself an abort fee with the lawyers. if you're going to, when you get up and running and if you need legal support, I would suggest that if you know any friendly lawyers, it's not such a bad thing to ask them to become a non-exec director of your business, because they'll give you a whole bunch of free legal advice. And they all love to be non-exec directors, because lawyers like to all pretend that they're really commercial and they're out in the real world. So it's great for their CV. They'll be delighted. And actually, you'll get an enormous amount of value from them, from paying them, little or nothing. In some cases, they'll do it for nothing. They'll just do it for the kudos. So if you know people who are in the legal profession, they might be inclined to support you on a pro bono basis, or take a non-exec role and provide you with a whole bunch of legal advice for not very much. The other thing is, you shouldn't really pay for anything on an hourly rate these days. So everything that you pay for that you need should really be fixed priced. So if you need a new suite of contracts to supply your services to someone, it should be a fixed price for that particular project. If you need a shareholders agreement, it should be a fixed price. Everything should be fixed. So don't get yourself into the position where you find yourself incurring all sorts of liability to lawyers. And many law firms have specific solutions that are focused around SMEs as well. So our firm has like a starter pack that we provide and a bunch of other little products and services that are designed for SMEs. And if you're engaging with a law firm and they don't have any of those sorts of products, then they're probably not the right law firm for you. So there's a lot of value you can get out of lawyers, but you just need to work them pretty hard and not just accept their standard terms. Finally, I think that about 90% of the value engaging with lawyers and professional advisors generally is delivered in about 10% of the time. It's not even 80-20, I think it's like 90-10. So you'd be really well advised when you're looking at some of these issues, like you want to decide what your corporate structure should be and think about trademarks and those sorts of things. You don't need to engage a lawyer for a continual period of time. You just need a first hour or so with them where you run through your ideas, they give you the advice, they tell you where to go online, where the useful information resources, and then you can just touch base with them again in the future, maybe for another half an hour session. But a lot of the work you can actually do yourselves, and there's a lot of very good resources online. And so you don't need everything hand building from a law firm for you at considerable cost. So if it was my money and I wasn't a lawyer, that's what I'd do. And when I engage with accountants, I do exactly that. So we have an hour and a half. They'll probably give you the first hour free anyway, because they'll think, oh, brilliant, this is going to be a really good prospect for us. So you get the first hour for free, get all of the answers, and then go away and do it all yourself. And I say that, but then from a law firm perspective, though, we don't mind just giving away those freebies, because actually, if we help you out and help you send your business in the right direction, 1 in, 5 of you guys, maybe 1 in something, will become massive. And one day, it's what goes around comes around, kind of karma type principle. You'll come back and say, actually, we're doing all of this stuff. We need a load of help. We've got employment contracts we need drafting. We've got property leases negotiating. We need to do tax planning. We need to do this. And if we've, as a law firm, had enough touch points with enough rapidly growing businesses, then it's a bit of a numbers game for us. There will be some that come back and that become very profitable for us. But it's actually in the initial engagements, it's a bit of a lost leader. So that's all I have to say, but I am conscious that the topic of the law is quite wide, and if anybody has any questions or comments or so on, I would be more than happy to attempt to address them.
As somebody who has to professionally be a data protection geek, do you have any resources on technology, security, data protection, data security that you would guide organizations towards? Because we get asked at Assembly that question quite a lot. Where do I go for best practice in these scary areas?
Good question. I think the ICO, Information Commissioner Office website is the best place to start in relation to data protection. It contains all of the relevant legislation and also various guides on what does this really mean for you as a business, what do you need to do. It's also got best practice guidelines there. It's a very good and resourceful website. The Information Commissioner, by the way, is the person who enforces the Data Protection Act. The Data Protection Act, if things go wrong, you can sue someone, or the Information Commissioner, as the policeman, can enforce the breach of the Act. And so when there are these high-profile data breaches, it tends to be the ICO, Information Commissioner's Office, that goes after people, and nowadays imposes very big fines. It used to be the case with data protection. I used to tell everyone to ignore it because there was only a £5,000 fine, and actually you'd spend more money trying to comply with it than you would actually just ignoring it and paying the fine. And then no one ever paid the fine either. But unfortunately, they spotted that and changed the law. So now I say pay attention to the Data Protection Act, because you can be fined £500,000 now. And it's not great going to the magistrate's court either, really, and getting a criminal record, because it's a criminal offence. But what else on data protection? Is there anything? Yeah, I'd certainly start with the ICO office. It's pretty good. I'm trying to think if there's some other good resources, but that's the best one that I've encountered. Oh, bear in mind the law's all changing in relation to data protection. So these armies of lawyers have built themselves up as data protection experts, and they've created all these teams and so on that specialise. And it's very complex because there's loads of legislation and there's loads of case law. But the neat thing is Europe has just abolished all of that. And in something like 2018, I think, the GDPR, the General Data Protection Regulation, is going to come into effect in the UK, and it's going to replace all of the existing law with a new law. So you could all become data protection experts just by reading the GDPR. You won't know any more or any less than any lawyer in the land, because they're all looking at it and looking blank at the moment. So that's 2018, it comes into force, so just bear it in mind.
Hi, George from Find Out Pressure. You talked about NDAs. They're fairly standard agreements, but I know a lot of companies will adjust them and have their own as a startup. Can you suggest any good resources to getting one ourselves?
Yeah, I mean, obviously, I couldn't suggest at all that you simply copy the content of any NDA and pass it off as your own. That would be obviously copyright infringement. But other than that, there are many places you can get an NDA. And actually, if you go to a law firm like ours and ask us for an NDA, we'll just give you an NDA, to be honest. I mean, normally they charge about £400, £500, £600 for a standard NDA, but most law firms will just give them away. And actually, you can sign any old NDA, pretty much. I mean, so long as, if it's reciprocal, you largely know that it's going to be reasonable. So if it's imposing the same obligations of confidentiality on both parties, so it's a two-way provision of information, you kind of know that it's a double-edged sword for the organisation presenting it to you, so they're not going to do anything crazy in the document. If it is a one-way NDA, I'm generally quite relaxed about signing them. As I say, all they try and do is invoke the law of confidence in relation to certain information, and even if you don't have an NDA, if you mark documents confidential, the law of confidence is still there, and it will still apply. You just need to make sure that you mark documents that are genuinely confidential as confidential, and you will get the benefit from the law of confidence.
It's quite common for companies to trademark a common expression. Is it possible, though, to trademark a common expression? So say, for example, I had a company hypothetically called Education Textbooks. That's a common phrase, but the way I produce education textbooks in a logo, perhaps with stars around it or something like that, and that goes on all my products and that's my brand name, is it possible to trademark that and maybe not necessarily the reference to it in sort of written speech, but certainly you can trademark the expression of a common expression? Is that
That's absolutely right. Yeah. So it's not just that you trademark words. Words are a part of the thing that you are trademarking, and as you quite rightly identify, if you express the words with colours, with logos, and so on, then the thing that you are potentially trademarking is the combination of what may be a phrase that is not trademarkable per se because it's descriptive, but within the context of a logo, etc. Just bear in mind though, if you go too far down that line, then it's quite easy to dodge around the trademark if you're wanting to set up another business, because if you want to set up another business using the same phrase, you'll check the trademarks, you'll see your trademark, you'll see it's wrapped around a load of logos and so on, and you'll think, oh, okay, this is easy, we'll use the same phrase, but we'll just do some other colours. And then you're not infringing the, well, simplistic to say you're not infringing, you might be, but you've certainly got a very good argument to say that you're not infringing that trademark. Trademarks as well are registered in classes as well, so it's not a monopoly IP right like patents, it's actually per class. And it's also a jurisdictional protection. So just because you've registered a trademark doesn't mean to say no one can trade using that mark all over the world. You have to look at what class you're going to register it in and also what jurisdictions. And inevitably, the more classes, the more expensive, the more jurisdictions, the more expensive. The classic examples in the olden days were sort of Jif, Lemon, and Jif. Now it's called SIF, because I think GIF in some foreign language meant something really horrible. So they called it SIF instead. But there was a time when there were two products called GIF from completely different suppliers, using entirely the same product name, but neither were infringing each other's trademark because they were registered in different classes. One was food products and the other was cleaning products. The other thing to bear in mind is it's not just trademarks that is an IP protection there. There's something called passing off. So if you're not... Well, the classic case on passing off was that... I'll keep it short because I know you don't really want a law lecture here, but I excite myself when we get into these topics. It was McVitie's and it was Penguin biscuits and it was Asda Puffin biscuits. So the brain boxers at Asda decided we're not going to infringe the trademark of McVitie's Penguin biscuits because we're going to have a puffin instead of a penguin, and we're going to call them puffin, which in no way sounds like penguin or is any way similar. But what they did is they had the same look and feel. So they were next to each other in the supermarket, number one. That's kind of looking like a bit of bad faith there. And they had the same concept of really deep like reds and blues as backgrounds with silhouetted birds on the front. Okay, one was a silhouetted penguin, the other was a silhouetted puffin. But it still was, the law of passing off basically says if you basically try and free ride on other businesses' goodwill and to confuse a member of the public into thinking there's an association between the two products, then potentially you're liable, and indeed, as they were liable.